Hello?
I think we have everybody in the gallery, right, Madam Clerk?
It appears so.
Yeah, okay. So, you tell me when you're ready to go on the record.
Alrighty.
So, good afternoon, everybody. This is Laura. I want to first acknowledge that everybody can hear me, so we have this in open court. Mr. Vanier, Mr. Collier, Ms. Bratton, can you all hear me?
I can hear you, Your Honor.
I can hear you.
Yes, Your Honor.
Okay, thank you. And then we have, it looks like Ms. Adams. Can you hear me, ma'am?
Yes, can you hear me?
I can.
Okay.
And then we have Mr. Collier. Is your client with you?
No, Your Honor. He's not appearing today.
Okay. And then on the second matter, we have Ms. Carrion and Mr. Javier Ruiz. Can you both hear me? Mr. Javier Ruiz? Can you hear me?
Yes.
Okay. So we are, for the record, in open court. This is the Douglas County Superior Court calendar for Tuesday, February 16, 2021. Parties are appearing via Zoom. Parties were provided notice of this hearing to comply with the Bone Club factors. I'd like to start with the first case, cause number 12-3-00020-5, Duncan versus Duncan, or now Adams. And this appears to be the mother who is appearing pro se's motion to lift supervised visitation. For the record, there was an email sent yesterday regarding the procedural posture of the case, and the mother replied that it's based upon the summons and petition that she filed May 16, 2017. So at this point, Ms. Adams, first off, since you're the petitioner, the court has reviewed your subsequent motion or declaration. Is that what you're basing this request on today, ma'am?
Yes, I was in touch with Northwest Justice Project, and they said there was a pending petition from 2018, and there has not been any adequate cause found or denied in that. So that would be working from that petition, and I'm asking for adequate cause to hear me today and lift the limitations on my parenting and allow a normal schedule.
And ma'am, the evidence that I saw was your declaration as contained, filed January 28, 2021, correct?
Yes.
Okay. Let me hear first from Mr. Collier on the procedural status of this before the court then rules. Mr. Collier?
Frankly, I'm a little confused to the procedural status of it because she actually filed a petition to modify on May 16, 2017. Then she filed another petition to modify in 2018 on July 31st of 2018. And then she filed a motion for adequate cause when she was represented by Ryan Gunn. And my understanding is that we had an adequate cause hearing on January 29, 2019, where the court didn't find it and stated that there was no changes at that time to the plan, and now we're back before. So I'm not really sure exactly the status of it based upon just the filings she's filed. I think she needs to file a new. I think my position is she needs to file a new petition to modify and outline the current reasons as why she thinks that there should be adequate cause.
Mr. Collier, Ms. Adams, let me just quickly review the minutes from that January 29, 19 date, because this was a longer file. Mr. Collier, Ms. Adams, was there an order reflecting that decision by Judge Hotchkiss then entered?
No, there wasn't an order. Mr. Guy was going to draft an order, and then he didn't. And my recollection of the hearing was that Ms. Adams was supposed to supply some other information. I don't think that happened. And then the next motion was that she wanted to change venue.
Right. Ms. Adams, is that correct?
The May 16th of 2017 hearing, I believe that Judge Hotchkiss ordered Collier to draft those orders. Those have not been presented, nor have any minutes from the January 29th, 2000 by either attorney.
Okay. Ms. Adams, Mr. Collier, here's what the court's going to do today. First off, with regard to the January 29, 2019 hearing, I see minutes. It does not indicate a formal not finding adequate cause, nor does it say who was to draft the order. So at this point, the court believes that this is still an open matter, that there was an initial petition filed in 2017, and then a subsequent one in 18, that there was summons and there was service. So this is still a pending action. Since then, there have been various hearings. The court did, for the parties' benefit, review in detail Judge Hotchkiss's ruling from 2017, where he denied the mother's motion for reconsideration. So I had some backstory to this case. To that end, Ms. Adams, here's the court's ruling today. The court is going to deny your request without prejudice based upon what you filed thus far. The basis that you put in your declaration speaks really to your change of circumstance and how you're living on this farm and how you're doing well, but it doesn't address anything about your particular change of circumstance as it relates to what's in the child's best interest, because the legal standard is to show that there is a substantial change in the circumstance where the child is primarily residing, which would be in the father's care and custody, and that hasn't been presented yet, ma'am. So the court doesn't have sufficient evidence to rule on this, and the court will therefore deny it without prejudice, which means that if you present further or new evidence since the past parenting plan was entered, the court will certainly consider that. The court is also a little confused why now, approximately 1 year later, since your last court filings, you are seeking this. You can certainly address that in any subsequent filings, Ms. Adams. So that's the court's ruling for today. And I would urge you to either work with Northwest Justice Project or the court facilitator to maybe get some guidance on the legal standard and what evidence needs to be presented in order to find adequate cause to modify the existing parenting plan and specifically to lift the supervision requirement. So do you understand the court's ruling today, Ms. Adams?
I understand, Commissioner Safar. And then also, I noticed that we were special set for a 1 hour hearing today. And I have been in connection with Northwest Justice Project. They have advised me on what to do. This is what I've done. That's how we're here in front of the court today. And the adequate the evidence that I'm relying on is based on my knowledge, because I don't get to see my daughter, and the court record has been preserved. It's all there for your review as to what my pleadings have been in the last 3 court hearings. Nothing has changed in those circumstances, and that is what I'm working from under the best interest factors, is the fact that my daughter has not seen a pediatrician since prior trial 2016, has never received any sort of counseling records that I can see or find, even though Judge Hotchkiss ordered that in August of 2016 to prepare me for trial.
Ms. Adams, I'm going to interrupt you here.
Okay.
You refer to your prior declarations. Is that where that information is contained?
Yes, the information would be contained in the Chelan County minutes, or, you know, what's pertaining to those minutes. That was supposed to be changed back to Douglas County, September of 2020. And
Filed in this, Ms. Adams, was that filed in this cause number? I didn't see that when I went through everything.
no, it's going to be, no, it still has not been changed. And so I'm working under the previous due to the fact that it was pending. And just give me 1 second here, okay?
Oh, here it is. I'm sorry.
Yeah. So in 2018, oh, I'm sorry, I should let you read, sorry.
Well, I'm just seeing this here now attached for some reason. And just so all the parties know, for some reason the computer is moving slowly. It's just not just me today, but it's the computer, so I'm having problems pulling up documents. But I see the cause number. It looks like it's 23166-04. It was a hearing before Judge Brandt in Chelan County last June. Is that what you're referring to, ma'am?
Yes, my exhibits attached to my declaration for today's hearing is referring to that case. And it also, I was in front of you February 18th and March 17th for a contempt motion. That was supposedly procedurally incorrect, but it's my understanding from administration, Joe Jackson, that, you know, basically because I recused Judge Huber and neither the clerk nor the administration nor the judge himself forwarded that on to you or someone that it should have seen by already by now. That it's just kind of a pending proposed, could be in an inbox somewhere. But the reason I wasn't procedurally correct in front of the court on February 18th and March 17th of 2020 was because the judge refused to sign that order and nobody sent it to anyone else to further it on. So we sat in court and did nothing twice.
Well, with regard to those issues, Ms. Adams, I do recall that. I remember hearing the case, and I don't think that was the issue. I think it was just procedurally not before the court properly. As to today's hearing, contempt is not before the court. You're seeking to modify. I will admit that for some reason I missed the reference to the Chelan County case documentation that you filed, so I would certainly be willing to review that and take this under advisement.
Well, then can we continue this on to a further date so that that can actually be reviewed?
Sure. So, let me hear from Mr. Collier on this.
That's fine, Your Honor. We can continue to a further date for hearing.
So what the court would be inclined to do, the next time that I'm scheduled to hear the calendar would be March 16th. Does that work for you, Ms. Adams?
Yes, absolutely. And what time would that be?
At 1 o'clock, same time.
Okay. And are you looking for anything? Sorry.
Clarity. When you say that you're looking and you see the Chelan County stuff, or you're referencing Chelan County, where are you seeing that? What document are you looking at?
It's sure. It's Exhibit C2 to Ms. Adams' declaration filed January 28th.
Exhibit C2.
That's how it's labeled here.
Okay, so the clerk's minutes?
Correct. That's what, and I haven't read them. I'm just scanning them here quickly.
Okay. But that doesn't have anything to do with, that has to do with the contempt. That has nothing to do with that clause.
No, I understand, but Ms. Adams is relying upon that, I guess, as her factual basis for her request for relief today.
Okay.
So, Ms. Adams, I guess my question to you, just to make sure I'm tracking, is did you want this court to look at the additional filings in that cause number, or just what you presented with regard to the minutes?
What I submitted in my declaration is the minutes for that case, and if you want to look further into it, you can. But my main concern is the 2018 being pending, and the fact that I have asked for contempt on February 18th and March 17th, and the only reason that I wasn't procedurally correct was because the motion for adequate cause was not signed. And I don't know where it went.
Okay. Well, here's what we're going to do, Ms. Adams. We're going to continue this to the March 16 date, so one, so that I can look at these minutes. Number two, if I determine that I need to look at the Chelan County file, I can do that. Number three, I will go back through the contempt issue that I heard before and certainly inquire whether there was some irregularity there. And we'll come back on March 16 and I'll have a decision for you with regard to that. If there's additional information that you want to supplement before that time, or you can reach any other agreement with Mr. Collier on, certainly I welcome that.
Okay. I appreciate your time today. Thank you.
You bet. Mr. Collier, anything else?